There are Girl Scout cookies in the back for anybody. But I want to say I'm very honored to be here today to introduce our speaker for the annual diversity lecture, Gary Orfield. And I first became aware of Dr. Orfield's work when I was working in Washington, D.C. And I went to the Hill, which is Congress, of course, to hear the efforts to increase access to higher education. And Gary Orfield was the featured speaker. And by the end, I was searching the Civil Rights Project website to learn more. I knew then that I'd heard from a wise and informed individual who thought deeply and with passion and commitment to the issues of social equality and equity. It's no surprise that he was awarded the Social Justice and Education Award by the American Educational Research Association in 2007 for his work, which has a profound impact on demonstrating the critical role of education research in supporting social justice. He has, for those of you who aren't familiar, he has wide-ranging research. He has 14 books focused on desegregation, affirmative action, racial inequality in special education, retention and dropout, standardized testing, and resegregation. And just a few of his book titles are Lessons in Integration, Realizing the Promise of Racial Diversity in America's Public Schools, Dropouts in America, Confronting the Graduation Rate Crisis, Dismantling Desegregation, the Quiet Repeal of Brown versus Board of Education, and Chilling Admissions, the Affirmative Action Crisis and the Search for Alternatives. So Gary's central interest is in the development and implementation of social policy with a central focus on the impact of policy and equal opportunity for success in American society. And his research spanning decades returns to these topics within this dynamic landscape of social change and how it evolves historically. So his talk today revisits affirmative action as a central topic to understanding higher education and its uneven pursuit of social justice. His work is best captured in the center he co-founded at Harvard, which is now UCLA, the Civil Rights Project, an initiative that's developing and publishing a new generation of research on multiracial civil rights issues. But he's not just an academic, for those of you who know him. He's a committed agent of social change. He's been actively involved with the development of government policy. He's participated in it as an expert witness in several dozen civil rights cases, including the University of Michigan Supreme Court case that upheld the policy of affirmative actions in 2003. And he's been called to give testimony in civil rights suits by the U.S. Department of Justice, many civil rights, legal services, and educational organizations. Unbeknownst to Gary, I asked a few of his colleagues to comment about working with him at the center. And here's what they said.
Wait a minute. I didn't get this part.
It's quite nice. Gary believes in his students and makes them feel they have a right and the ability to change the world. Gary's goal is to help others shine and to become stars that the world really needs. Another said, Gary's vision of justice is contagious. He believes that good will always eventually win out. Another said, Gary shows that you can make a career out of working hard to make the world a better place. And finally, this was my favorite. You know you did something major when Gary buys you ice cream. With this final comment, I wanted to thank Gary personally for coming today and speaking with us. And I look forward to the day that he buys me ice cream. Thank you.
Well, it's been said that ice cream doesn't solve all problems, but it doesn't hurt any. I always give my doctoral students an ice cream cone for each chapter. And if I ever forget, they get very upset. One of my theories in negotiating major civil rights cases, sometimes when I've been working with a judge and so forth, has been that everybody is really a little child in some way. And there's always things that delight people and things that they're upset about. And since I'm the oldest of 6 kids, I always think, you know, when I had to settle the fight between my 2 little brothers, I would have to make sure one of them got the red car and one of them got the green car, and then each one of them was special. It's kind of what you have to do sometimes when you're dealing with 2 lawyers that are a huge battle in federal court. But to go to our serious business for today, we are at a very, very critical historical moment in this country. We probably have the most conservative Supreme Court in 80 years, maybe more, in terms of civil rights issues. And we are probably going to lose affirmative action before the summer and by the end of June. There are 5 votes on the Supreme Court that have never voted to sustain affirmative action. The only possible, there's one justice who would support affirmative action who has disqualified herself from the case because she was involved in the Justice Department. This is a case that is impossible to win. And the best that could possibly happen would be a 4-4 tie, which would leave it undecided. But it's very probable, most lawyers who've been involved in these issues and most observers of the Supreme Court believe that there are 5 votes that will limit or abolish affirmative action in a serious way in the University of Texas case that we're talking about. This would be a devastating change. And there also is a case before the Supreme Court on voting rights, which could lead to an interpretation away of a major part of the Voting Rights Act. That would be 2 of the absolute pillars of civil rights interpreted away by the highest court. In 2007, school desegregation was very seriously undermined by the same court in a 5-4 vote. So it's a very, very serious period. When I was in graduate school eons ago at the University of Chicago, I'm a political scientist. One of the fields I took was contemporary history. And I studied with a great scholar, John Hope Franklin, perhaps the greatest black historian of the 20th century. And the seminar I took with him was about the post-Reconstruction America, when virtually all of the civil rights that were won in the Civil War were interpreted away by the Supreme Court, ending up with Plessy versus Ferguson in 1896. And how almost nobody in the academic world paid any attention to it, aside from some scholars in black colleges, most of which were under the control of white politicians in any case. But basically, almost everybody just passively accepted it. And I thought at the time, you know, that it's very important that that not happen again. And now that this is happening again, it's very important that all of us think about it and think about the consequences, think about the issues that are before our country, and think about what happens if we lose some of the rights that were won through generations of struggle. And that loss is actually imposed by the court that used to be thought of as the protector of minority rights. That court was transformed in a period of 25 years when no Democratic president got to name a justice. It just happened to be that the court got overwhelmingly representing the conservative side of American politics. Right now it's almost a completely polarized court, 5-4 on almost everything. What I want to talk to you about is what this struggle is about, what the context of it is, what the issues are before the court, how we try to be involved with this in creating a brief that was signed by 444 scholars from 42 states that went to the Supreme Court, and help us begin to think about what happens if we do lose or we have substantially weakened the policy of affirmative action, which is already a fairly weak policy. So that's what we're going to do today. Can you hear me back there? If you can't, let me know, because I'm a teacher and I don't have a loud voice, so let me know. Let's see if this technology is going to work. Yes. Oops. So we are faced with the threat of losing a serious policy that really has been in place by almost all the selective institutions in the United States for half a century. We now have 46% students of color in American public schools. In the West, it's for 52%. This is as of a couple of years ago. Southern California has 75% students of color in our public schools. Each year, that's changing a little more. We are in a crisis of higher education access. For decades, we were the leading country in the world in terms of successful higher education access and completion. We now rank 16th or 17th. We're falling behind some communities, some places in South America, some small Eastern European countries. It's very depressing, and it's exactly in a time when education has never been more critical to economic development and individual success in our society, and the success of groups. So at the time that we're going through this incredibly dramatic demographic change, the United States was between 10 and 20% non-white for 200 years after its founding. It's now going through an epoch-making change in its demographic structure, especially of the younger generation. Just as we face that, and as education has become more critical to opportunity than ever before, we're facing a decline in college success. It's serious. And this is happening even with affirmative action. Affirmative action is outlawed in California and a few other states, but it's still in place in well over 40 states. We have a basic failure to educate non-white students, and we are segregating them in more and more unequal high schools and elementary schools. That segregation has been increasing in our public schools ever since the Supreme Court changed the law on school desegregation in 1991 in the Oklahoma City case, where they said it was all right to end desegregation plans and return to unequal neighborhood schools, and pressed lower courts to do that. Since that time, almost all major desegregation plans in urban areas in the United States have been dissolved. Only a few remain. And we have coming a smaller generation. Our high school population has passed its peak. It probably its peak was in 2011, 2012. It was a little bit earlier in California. We're going to have a declining number of high school graduates because there's a declining number of people in that age cohort. So these are going to be less white and more disadvantaged, since most of the children going to public school in California are now poor enough to qualify for free lunch. And they're going to be less prepared for college, and the colleges are going to be dealing with multiple set of crises. So why is this important to universities? Student population is changing. If they don't figure out what to do about this, they're not going to have students. Certainly not students who are prepared. There's just a big article I read last week in the Wall Street Journal that said New England's in trouble. New England is shrinking in terms of population, and all of its growth, where there is any growth, is international immigration. We haven't figured out other ways to bring students in other than affirmative action and other kinds of support systems. We know from lots of research now that education is more powerful when it's diverse. So it harms the educational power of universities if they become less diverse, as they may very well. And we do know that students who are admitted from affirmative action succeed at universities, especially the more selective the university, the more likely they are to succeed. And of course, work like Bowen and Bach's classic book, that follows students longitudinally in their lives, shows that they make major contributions later on after college. So there's lots of reasons why this is really important for universities. It's also really important for public universities because they're supported by the public. If the public is 3/4 non-white and the university enrollment becomes closed to the majority group in the non-white public, the political support for the universities is going to decline, and the ability of the universities, professional schools, and so forth to provide people who actually serve the people who are living in the state is going to decline. Now, we have a history of segregation in higher education. We don't talk about it very much, but the truth is, up until the 1960s, almost all of our institutions of higher education were segregated to a considerable extent. In 19 states, they were segregated by law. That's all the states of the Old South. All of the one-time slave states. The 11 states of the Confederacy, the 6 states of the border region from Oklahoma to Delaware, and 2 other states, Ohio and Pennsylvania, had separate public colleges set up for black students. So we have this history of segregation by law and by official action in 19 states. And we have segregation by practice almost every place else. In most elite institutions, there were almost no minority students who were graduating up until the 1960s. When I was an undergraduate at the University of Minnesota, when I was asked, because I was running a student government, would I orient some American Indian students to come? And I thought, well, really, I would like to, but I'm ignorant. So I organized a visit to some reservations and learned of a lot. That was one of our largest non-white populations at the time, extremely disadvantaged. And I visited one official at the state capitol and said, we've had a wonderful growth of Indian students at the University of Minnesota this year. It was a 30% increase. And I said, how many do we have now? And he said, 12. That was a wonderful growth at that time. So we had officially unequal higher education. And that was true for the area where the great majority of African American students lived then and live now and have always lived, which is the South. Basically, they were in places they were officially excluded. That became illegal, of course, with the Brown decision, but nothing was done about it for about 20 years after Brown. Outside the South, almost all the elite institutions, public and private, had very small non-white enrollments. And almost all of them decided sometime in the middle 60s that they needed to do something about it and adopted affirmative action plans of one sort or another. They did that during the civil rights movement, during the time when there was a lot of consciousness of these issues in the country, and when they looked around, also their students were raising hell on the campuses in many cases, especially the small groups of minority students, demanding that something be done. And most of the colleges did something, and they did become diverse in one way or another. Lots of times, not in a very brilliant way, because nobody really knew how to do this very well at the time. Now, the best time where the positive conditions for access and equality was about 40 years ago. Sorry to tell you this, you guys who weren't born then, you missed it. But if you think about the things that make college access possible, ample space. All the colleges expanded a lot in the 1960s into the early 1970s. There were lots of open access public universities. And most private colleges have always been more or less open access, although they claim to be selective. So it wasn't, there was plenty of spaces, there was low tuition. We still had places there with free tuition, like the City University of New York. When I was a student, my first survey, my first piece of research, survey research, was when I was a sophomore at the University of Minnesota, and they proposed to raise the tuition. And I did a survey and showed that a bunch of students would drop out. I got all the institutional research people to tell me how to do the sample and everything. We sent it over to the state legislature, and they blocked the tuition increase. The administration wouldn't talk to me. They were really glad when I graduated. But, you know, tuition matters. It used to be that you could earn your own tuition, that you could work in the summer and have a part-time job on campus and pay everything. And, you know, that didn't really change dramatically until beginning in the 1980s, when the policy was to cut federal and state funding for higher education and to shift the burden to students. Basically, anti-tax movement said we're not going to pass any taxes, but we'll let all the institutions tax their students, and they can take the blame. Of course, that was an intergenerational shift, a shift of the burden from an earlier generation that had low college costs to a generation that has not had low college costs. And that's continued ever since 1980. Almost every year college tuition has gone up faster than family income. So we created a huge financial barrier where there was almost none to public universities. Federal financial aid came in 1964 and 1965 as part of the Great Society of the Johnson administration and the War on Poverty. That's when work study was created, that's when the Higher Education Act was created, it became the Pell Grants. That was a period of ample aid that actually paid much of the cost of going to college through the Pell Grants, what became the Pell Grants. And it was aid that was expanding, both at the federal level and the state level, and it was aid that was targeted by need, not by test scores or merit, as they call it. Affirmative action had just come in and was in place and was going fairly strongly before the Bakke case was taken to the Supreme Court in the late 1970s. In 1976 and 1977, high school graduates who were black and Latino had about the same chance of starting some kind of college as white graduates. The only time in our history. And we began to lose it fast in the 1980s when all the policies began to change. So in the 1970s, the University of California at Davis Medical School was challenged, and the challenge went to the Supreme Court. Alan Bakke claimed that he was discriminated against by the University of California at Davis Medical School. The medical school had set aside a certain number of seats for minority students. They'd actually set them aside. It wasn't just a consideration, it was a kind of a quota. And the question was that constitutional or not? And there was a huge fight. Lots of places in the early days of affirmative action had done things like that. When I was teaching at Princeton, when I was young, at the Woodrow Wilson School, the public policy school, we had a policy of 1/4 black students coming in. They were coming in from Newark and all over the place. It wasn't a secret. But the Supreme Court said, no. Setting aside seats is unconstitutional. You cannot do it. Bakke narrowly upheld affirmative action. There were actually 4 votes to overturn it, 4 votes to support it, and in the middle was Justice Powell, a fairly conservative judge from Richmond, Virginia, who had been on the school board of Richmond and really delayed school desegregation and so forth. He was not a liberal. He once wrote an article saying Martin Luther King was a communist. So he had to decide about affirmative action. And he decided affirmative action could exist, but only for the purpose of strengthening the diversity of education. Not to make up for the history of discrimination, only because universities had an interest in diverse education. And his source for that was a report by a faculty committee at Harvard. If you look at the history of American education, a lot of things happened because somebody at Harvard decided to do something. That's how we got the Educational Testing Service, because they wanted to identify smart students from Montana and other places where they didn't know, the prep schools and so forth. Justice Powell was a graduate of Harvard, and he said this committee had come up with a compelling reason, because it made Harvard better to have students who played the bassoon, and better than have students that played hockey, especially hockey. They take seriously. It's one of the only things they ever win. And students who are wonderful at anything. Harvard has always considered people not just on one spectrum, but on a multiple dimension. He said it's okay to do like Harvard does and decide to add race and ethnicity to those set of issues that you can consider. But it can't be the determining factor, it can only be a plus factor, whatever that means. Nobody ever knew quite what it meant. And since the decision was 4 on one side and 4 on another, and Justice Powell in the middle in a very confusing way, colleges kind of began to pull back from the really aggressive efforts that they'd done before Bakke. But they continued affirmative action plans within the framework of Bakke. In the 1980s, following the Bakke decision, which was 1978, all of the positive conditions began to erode. Tuition began to go up constantly. Federal aid was cut, and the degree to which the Pell Grant covered the actual cost of going to a four-year college eroded really seriously. A substantial racial gap reopened in terms of initial access to college after entry. Economic stratification increased a lot in the society, and it's been increasing ever since in terms of the distribution of the income. As unions were crushed and income became more unequal in lots of ways, apart from the tax changes that were instituted. School desegregation began to be blocked. It would really be blocked seriously in the 1990s. Another decision in the 1970s, the Supreme Court by 5-4 vote voted against equalizing funding of public schools attended by poor kids and rich kids. In that case, which was called Rodriguez, which came from San Antonio, the court said education wasn't a right that was in the federal Constitution. Therefore, if it were delivered unequally, it didn't violate the 14th Amendment, equal protection of the laws, because there is no right to education. Brown versus Board of Education has said education is the most important thing public institutions do. But by the time of the Rodriguez case in the 1970s, they said there is no right. It doesn't really matter that we have unequal funding of schools. So people began to sue in each state to try to do something about that. The Reagan administration created a new theory about what the equal protection of the laws meant. And they began to popularize it. Also, they began to recreate the federal courts with appointments of extreme conservatives. So what their theory was, the theory in the civil rights era of the Supreme Court was, you can consider race to solve the problems of race. You can't really solve them without considering race. You can have a systematic approach to doing that. That's what affirmative action and employment and college access are about. You assess the inequalities and you try to plan to work against them, or what voting rights is about. You don't let people impose new voting rules and procedures that will have unequal effects on minorities. But the theory of the conservatives was, it's just as bad to consider race in a positive way as it is to consider it in a negative way. We just have to pretend race doesn't exist and just look at individual cases of individual discrimination, which would mean, since there's hundreds of millions of people in the United States, having millions of cases if you were going to actually try to address all these things on an individual level. But their theory was, it's just as evil to consider race positively as negatively. This seemed to be preposterous when it came forward from Ed Meese and others in the Reagan administration. But it would become the law of the land in important ways as time passed. Now, when the University of Michigan case went to the Supreme Court in 2002, there was a feeling that the Supreme Court might be ready to end affirmative action, because they had already cut back on affirmative action in employment, and they were already suspicious of what are called race-conscious remedies. In other words, where you consider race to solve the problems of race. So a lot of people thought maybe the time had come for the Supreme Court to end affirmative action. And the University of Michigan was sued in two lawsuits. One is called Grutter and one is called Gratz. And the important one was the Grutter case, which was about the University of Michigan Law School. Because the University of Michigan Law School had a policy that was exactly modeled on Bakke. They considered race, but only as one of numerous factors, and they did it in the appropriate way, and so forth. So what happened at that time was there was a huge mobilization of higher education, led by the University of Michigan, invested well over $1 million in creating research about what the effect of diversity had been on their students. Some very compelling evidence to show that not only had it had a beneficial effect on racial attitudes and so forth, but actually it was related to increased cognitive complexity and understanding and ability of students to take, to understand things from other people's perspectives, perspective taking, a variety of other kind of really important intellectual developments. We were very involved in that in the Civil Rights Project. The Civil Rights Project was created in 1996, the year that affirmative action was abolished in California and Texas. And the reason it was created was Chris Edley from Harvard Law School and I decided that the academic world wasn't producing the kind of research that was necessary to guide policy on these issues. We came to that conclusion after we had a secret meeting over at Harvard of 25 college presidents, civil rights leaders, researchers, and so forth. And we found out that in the years after Bakke, almost nobody had actually documented the benefits of diversity for all students. And we began to commission a lot of research. By the time of the Michigan cases, we had the research. We had a lot of research, and we had several books out from different research groups. And the University of Michigan did a lot of research. And that all mattered, as it turned out in this case. One of the surveys we did, for example, was a survey of the law students at Michigan and Harvard. And we did a web survey of many other law schools to find out whether the students actually were learning different things when they were exchanging ideas across racial and ethnic lines. It was, of course, an anonymous survey. The results were overpoweringly positive. And they were extremely similar. Whites, blacks, Asians, Latinos, they all felt by huge majorities that it had changed and enriched their legal understanding and their ability to practice in their profession. So we had a lot of stuff like that, and it was presented to the court in many ways. Many, many institutions of higher education intervened by doing Friends of the Court's briefs. The Michigan people put really good evidence into the trial. And the students were allowed to intervene in the trial, and a number of us were asked to testify in the trial. So the record was rich, and there was a major mobilization. Now, in that decision, it was a 5-4 decision. Justice O'Connor, Sandra Day O'Connor, a Reagan appointee, quite a conservative person, wrote a really powerful decision. If you haven't read it, Grutter, it really does explain a variety of dimensions in which affirmative action had contributed, not just to the universities, but also to the military, to business leadership, to American democracy. It was quite an eloquent decision, much better than Justice Powell's. And we kind of thought that meant the issue was settled for at least a generation. The Supreme Court doesn't dig into these cases all the time. It's been 25 years between Bakke and Grutter. So Justice Kennedy, who will turn out to be a central actor in what we're talking about next in the Texas case, said he felt Michigan wasn't really being honest, that they really did have a kind of implicit quota, and that he said diversity was a compelling interest, but that they were being dishonest, and anything that looked at all like there might be a proportion that related to anything would be suspect. And so he dissented. There were 4 dissenters. what happened after the Ritter decision was that basically the issue was challenged not in the colleges initially, but in the public schools. In a case called Parents Involved that went to the Supreme Court in 2006. This is just 3 years after the Supreme Court had upheld affirmative action quite sweepingly in the Grutter case. In the Parents Involved case, which is really two cases from Seattle and Louisville, we worked very closely with Louisville on this case. The question was, all right, the Supreme Court has already said most of the mandatory desegregation plans in the country should be dissolved, and districts can return to segregated neighborhood schools if they want to. How about if they don't want to? How about if they actually want to maintain integrated schools? Will they be allowed to? And the classic way that integrated schools were maintained, and a way that had been encouraged by the Supreme Court for decades, was to run magnet schools, for example, where they would set aside a certain number of seats for minority students, a certain number of seats for white students, make sure they were integrated. So different students would not have the same chance of getting into any particular magnet school, but the schools would actually be integrated. This had worked and it was very popular all over the country. So the question is, did that violate the rights of individuals? Individual white students started suing, saying, you know, my student would have gotten in if he was black, but he didn't get in because he was white or because he was Latino or whatever. Therefore, that's discriminatory because my race has affected my destiny in this case. The basic problem, the basic reason why these controls had been put on is choice programs without controls, which had been widely tried in the 1960s, almost always produced resegregation. So this was what they saw as their option. So the Supreme Court in 2007 overruled all these precedents and said, no, you can't do that. You can never assign a student to school on the basis of their race or ethnicity. And they said Justice Kennedy was the key author of this. Now, what had happened to the Supreme Court since that point? The lower courts had said, sure, you can do that because it's, you know, basically integration is a compelling interest for the society. And this is a reasonable voluntary action. The courts aren't imposing it on any school district. Justice Kennedy said, well, he thought integration was a wonderful thing, but you could never do this. So he said it would be a good thing, but he took away almost all the tools the school districts were using. And the result has been major resegregation of magnet schools around the country and deep discouragement of people who want to maintain integration. There's a few districts that are doing it anyway. Berkeley is one. Louisville, where we've been working, is another, but many places just abandon the effort. And the schools are much more segregated now for black and Latino students than they were 40 years ago. They're not as segregated as they were before the Brown decision, but almost all the progress of the last 40 years has been lost in public schools now. So once this decision came out, then people thought, oh, we're going to try to get a case up before the court on affirmative action. So the case came from Texas. This is what Justice Kennedy's views are. He is the United States Constitution right now. He's the person that decided, for example, that corporations have unlimited power to spend money on political activity. He is the only voice, one that ever changes sides between the moderate liberal branch, 4 justices, and 4 extreme conservatives. But his view is that Michigan had a quota. His view is that you shouldn't decide any student on the basis of race, and he will decide this case. And he was very skeptical of the civil rights side in oral arguments that took place a couple months ago. The Fisher case in Texas is one student challenging the University of Texas. The University of Texas has an admissions process that has two dimensions that are relevant. One of them is the so-called percent plan. It says any student who's in the top 10% in any high school in Texas has an automatic right to go to the University of Texas at Austin. Now, some of you know there's a bunch of campuses of the University of Texas. This is the only really competitive one. And this is very competitive. It is a very dominant institution in the state. It's not a state with elite private colleges, except for Rice. So this one student said she didn't get in, and she thought she didn't get in because of her race. Because in addition to the percent plan, after the Grutter decision, Texas reinitiated a small affirmative action plan, which was particularly important for bringing some African American students in. Texas is a state that has 40-some% Latino students, 1/8 African American students, about 12%, and a declining white percentage, not population. Now, this case, it turned out this young woman didn't really want to go to the University of Texas. She'd already enrolled at LSU, and they did not make it into a class action. So it was not a big challenge on the part of a whole class of people, which is what you typically do in a civil rights case. It was one individual student challenging the university. Now, why did she choose Texas to challenge? She chose it because they had the percent plan, and that could be argued to be enough. That's in fact one of the things that the Bush administration had argued before the Supreme Court in the Grutter case. The key fact is that Justice O'Connor was gone and been replaced by Samuel Alito, very, very conservative justice, who was very hostile to these issues. So basically, the Constitution hadn't changed, the issues hadn't changed that much, but the court had changed. They've gone from 5-4 one direction to probably 5-4 the other direction. The University of Texas thought this case was frivolous in a way because it was a student who really didn't want to go, who they didn't think was qualified anyway, and there were all kinds of flaws in the trial record. So they did not do what Michigan did. They did not spend $1 million and develop evidence and so forth. They just argued that the case should be thrown out. But the Supreme Court took the case. So all of a sudden, we have a record that's framed only about this one student in this case that was not developed very well. And if you know about courts, all the facts have to come in at the trial. The higher courts are only supposed to decide about legal principles. You know, they don't hear any witnesses, they don't hear any experts or anything like that. They just read the papers that come from the trial. Well, the trial record was terrible. So how do we get evidence into the Supreme? And of course, none of it was about a lot of other issues. The Latino and black students weren't allowed to intervene. So it's the University of Texas protecting its own policies. So they weren't kind of representing the whole situation in the country that would result from affirmative action. This is where research really begins to hit law. It did hit it in Grutter. In the Grutter decision, in Justice O'Connor's decision, she cited a book that we did, a brief that we wrote, a book that was done at Stanford, a book, about 4 or 5, the Bowen and Bach book. These were all cited as fundamental reasons for making conclusions about the nature of affirmative action and so forth. This trial record didn't have it. The courts could be less hostile. What do we do in this situation? This is what we were confronted with. How can we show under what conditions the percent plan would work and where it wouldn't work? If you're going to make a decision that affects the whole country, shouldn't there be some representation of the concern of private colleges? Because none of them admit students on the basis of their high school rank within one state, which is what the University of Texas's plan was. Shouldn't we have some consideration of graduate and professional school admissions? We can't do a percent plan for those things. You know, can we really make a rule for the whole country that affects our whole social structure in an important way on the basis of one student in one university campus? How can we get some other issues before the court? So we decided, and others did too, tried to mobilize the scholarly community to intervene in some way. Because the only other way you can get any facts before the court are through filing what are called amicus briefs. That's a friend of the court document. They don't have to pay any attention to it, but they often do if they're good, if they're well done. But you know, you can speak truth to power, but power doesn't have to listen. But at least you can speak. Now here's what the American Council of Education and 39 higher education associations said in their brief. There were a number of briefs. It's nothing like the Michigan case. There wasn't the same kind of mobilization, but there were a number of briefs. So the university, the leading university lobbies in Washington did intervene, and they did speak to the compelling value of diversity, that it prepares students to engage with the modern world, that it serves the indispensable goals of higher education, inspires students to lead the examined life, prepares them to maintain a robust democracy. These are the kinds of things Justice O'Connor wrote about. We don't know whether Justice Kennedy's going to be concerned about them, or whether he's going to say he agrees with them and then cut him off all the means of accomplishing them. So what we did right away was to convene a group of experts from around the country, and we appointed a lawyer to be the counsel of record for this group. And we began to have a seminar every Friday morning on conference calls, basically, and exchange memos in drop boxes and so forth about what we thought were the most relevant pieces of research that would speak to the issues the court had to confront, about whether or not things like the percent plan could be considered adequate means to get diversity. Because under the rules of the court, if there's an alternative that doesn't involve considering race, you have to do that first if it would actually work, because considering race is only a last resort. This issue is called narrow tailoring in constitutional law. You have to prove that you have a compelling interest, which is the diversity issue and all of the benefits, and B, that your remedy is narrowly tailored. In other words, it's cut as close as possible to the minimum use of race. So you have to consider whether there's an alternative. So what we tried to do was to address a number of the questions that weren't in the record. And we worked closely with the American Education Research Association, which did a brief on the compelling interest, using some of the same scholars in many cases. We had done a brief for them in the Gritter case that the court had paid a lot of attention to. So one of the things we did was we tried to document what had happened other places when affirmative action had been lost. Of course, looking at ourselves at UCLA and California and other places where affirmative action had been cut. We tried to show the circumstances under which a percent plan can produce diversity and can't. A percent plan basically depends on high level of school segregations, because the way you get students who wouldn't otherwise be qualified in the percent plan is because they're in the top 10% in a school where everybody's black or everybody's Latino. Well, it turned out in Texas there are very few schools where everybody's black. There's a lot of schools where everybody's Latino. In fact, in the whole Southwest, there's very few black schools left. Very few in California now. Basically, blacks are in schools with lots of Latinos. So we said, you know, this works to some extent for Latinos, although it underrepresents them seriously, but it doesn't work worth a darn for blacks. You know, they can't be identified in this indirect method in Texas. They could be in Alabama or Mississippi. It'd be hard to identify Latinos there, because they wouldn't be in schools that were segregated. So if you're going to depend on segregation, you do a lot of things. One of the things is you eliminate a lot of the potential middle-class minorities who could be very successful in your university, because they're not in segregated schools. And they may be in very good schools, but they may be in the 11th or 12% rather than the top 10%. Another thing you do is you get students who on average are going to be less prepared in some ways for your university than under affirmative action. Another thing you have to do is invest a lot of extra money. Texas has created scholarships that are dedicated to particular high schools, for example. And the chancellor of the university goes over there and recruits from them. Says somebody in this room is going to get a scholarship. And there had to be a big support system. So the percent plan, to the extent that it didn't work, and it didn't work that well, depended on a lot of things, including segregation. It didn't exist other places. So we submitted statistics that showed, for example, there's a lot of places you couldn't identify students successfully by using a percent plan. And in many places, there are groups that you couldn't identify. But almost only in Alaska and 2 or 3 other states could you really identify any Native American students, for example, through a percent plan. So we're trying to get them to think about what the implications are. One of the things we pointed out is that, Texas, 95% of the students go to public universities. In New England, most students go to private universities. This just wouldn't work at all in New England, because none of them define their universes as a state. They try to recruit wherever they can. So they couldn't do it through the percent plan. There isn't an alternative that would work even halfway decently. And then there's a number of states in the country that have very low minority populations, that just don't have any concentrations that are large enough to really have something like a percent plan work. So Texas Latinos are twice as segregated as blacks. One of the things that the people did who were challenging the Texas plan was to combine the black and Latino numbers. They were doing fine. But blacks and Latinos have separate rights. And of course, blacks have been historically, officially segregated by all the Texas universities until overruled by the courts. Texas universities have gone to extreme stages of even building a separate law school to prevent one black student to come into the University of Texas. In an earlier case, the Sweat case of the Supreme, that had led up to the Brown decision. There are few schools with Latino concentrations in major parts of the South, even though Latinos are migrating into the South fast now. The most segregated schools have the weakest preparation for college and exclude many of the strongest students. The university wanted to have the ability to choose the strongest students. They didn't want to have to do this on a formula. No university wants its whole student body controlled without any ability to consider exceptional circumstances. All of them. How many of you have been on admissions committees? In admissions committees, when you read the files and then you know the students and you see them go through their careers and so forth, you remember when you spotted this letter or this fact about the student that just said to you, that student's going to be exceptional. No logical way that we could admit them, but we have to admit them. Every university wants to have that power because there's things that we can recognize that aren't part of a formula and that do predict powerfully what actually happens and what a student adds to the class. One of the things we presented was that, everybody says there's alternatives, but nobody actually supports these alternatives very well. This is a chart of the University of California's. They made a deep commitment after they lost affirmative action to do outreach and support systems and so forth. So that commitment reached its peak about 3 years after affirmative action was lost. And pretty much it's been drastically cut back. It's been cut back by 75% in real dollars. That's because universities come under pressure to do everything else. And this is not one of the most powerful political forces or lobbies that drive the allocation of scarce resources in universities. So if we're going to depend on the goodness of universities in allocating their scarce resources, a lot of the people in the UC system really want to have diversity. But when it came right down to it, they did not support it in any kind of consistent way. There were other things that they decided were more important. we showed them what has happened over time in places that have lost affirmative action. And you can see here that back in 1995, if you were African American, you applied to the University of California and you met the eligibility criteria, you had a 48% chance of getting admitted. You go to 2010, you have a 13% chance of getting admitted. That's in spite of the fact that we have instituted a massive comprehensive review system to try to look for all kinds of other dimensions of students' capacity. If you're Latino, you had a 55% chance of getting admitted. Now you have a 14.8% chance of getting admitted. Now everybody has less chance of getting admitted to the University of California. We had almost 100,000 applications for UCLA this year. Just hysterical demand. The average student that we're letting in has an A+ average. You know, it's crazy because we have not increased the capacity like they did back in the 60s and 70s. We've just increased the competition. So what we showed was over time, you know, you really do shut the doors for an awful lot of people. But we also showed them evidence, you know, Justice Thomas believes that students who are black are really embarrassed when they get in from affirmative action. And that there's a humiliation that goes with it. You know, that he suffered that at Yale Law School and things like that. But what we did was we got survey evidence that showed that stigma, the claim that there's stigma related to affirmative action is not empirically supported. Because we looked at information, we actually got survey data from colleges both in California and in Texas. And where there was affirmative action, the African American students felt more positive about their institution than in places there wasn't. You know, we've had some really serious problems down in UC San Diego, for example, with a very, very tiny black population. The students in Texas come from a de jure state with a heavy southern background and so forth, feel more comfortable than the students in the UC system about their situation, in part because they're not so isolated. They're not such tokens. They're not, you know, everybody isn't looking around at the one black student in the class to say, well, what's a black perspective on that? You know, there actually is a diversity of black voices and there's the diversity of Latino voices. And we found that the best students aren't coming to, the best African American and Latino students are tending to go to private colleges now because the UC can't compete because they're not allowed to practice affirmative action. So, you know, we're losing some of the very, very best students that we want to have that would add a lot to the educational experience. These are some of the issues we covered in our brief. If you do a brief for the Supreme Court, there's a ritual process. You have to connect each part to part of the legal argument, and you can only have 9,000 words for everything, which is absolute killer for a group of academics. We had so many things, so many important pieces of research that went out the window because we just didn't have enough words. And we had to document everything that we put in there, but this was hard, very hard. So what we did was we kind of developed a scholarly consensus through this ongoing rolling seminar. Drafted a document, sent it out to other people around the country, got their comments, made their corrections, and eventually this brief was signed by 444 scholars from 42 states, 172 universities and research centers. These are all faculty members or professional researchers. And we presented it at the National Press Club, and it's been widely used around the country. We have no idea whether anybody on the Supreme Court will read it, whether one of their clerks will read it. One of the problems when you're involved in these things is none of these people are going to decide the fate of this issue, in all likelihood, have had any statistics training. None of them are really researchers or understand this stuff very well. They have to make the decisions for the future of our country. Figuring out how to translate that so it's reasonably understandable and yet credible and honest. Very complicated. I thought I would tell you something else. There were other institutions and other interests that intervened in this case. The military. The military is not in favor of affirmative action because they're liberal. You know, they're in favor of it because they want to win the war. You know, they are in favor of it because when they had segregated officer corps in Vietnam, there were enlisted men shooting officers. You know, this is not a theoretical issue for them. This is an issue about whether the Army works, whether they can fight together, and so forth. So they intervened in the Supreme Court in the Grutter case, and they've intervened again in this case because they need to have integrated, and they do have very active affirmative action. Very active. You really can get fired if you don't meet its terms because they consider it a survival thing. In their brief, in the brief of military leaders in this case, they said it's essential to produce a diverse group of officers trained in a diverse setting. You have to maintain a racially diverse officer corps and a commitment to which nothing less than the effectiveness of our military depends on this. This is a must-have for national security. When I was teaching at the Kennedy School at Harvard, I was teaching a class on urban inequality, and one time, and there were 2 Canadian generals that enrolled in it. They were on leave for Kennedy School, and I said to them, I said, you know, I'm glad to have you in class, but I can't imagine why you're taking my class. They said, well, you know, everybody in Canada who really thinks strategically knows that the major risk to Canada is the United States falling apart. Business has a similar kind of reason for intervening. They want to sell things, they want to manage people, they want their workforce to work together. It's not an ideological issue, it is an institutional survival issue. This is a brief that was filed by 57 Fortune 100 corporations. And they said, graduates of diverse colleges have an increased ability to facilitate unique and creative approaches to problem solving by integrating different perspectives, moving beyond linear conventional thinking. That's exactly the kind of stuff that the Michigan brief said about the students. They're better equipped to understand a wider variety of consumer needs. And if you've got a market that's 50% Latino and nobody understands anything about the customs of that, you're just going to lose market. So they made this argument in their brief. Basic attacks say it's unnecessary, it stigmatizes students, and they fail disproportionately. One of my colleagues at UCLA Law School filed a brief saying, you know, they're less likely to pass the bar exam. Although that's a very controversial claim that I don't think is supportable. And the claims that white students have been harmed by not getting admitted when they would be otherwise. That's the basic issues that will be in the minds of the conservatives on this side and are in their briefs. The reality is that even with affirmative action, we are in trouble in lots of ways. Because African Americans have 1/5 the chance of attending a selective college that whites have, even with affirmative action in place. Latinos have 1/3 the chance. You know, these are really large gaps. Affirmative action has not solved this problem. It has contributed to maintaining some level of diversity, but it has not produced equality. It's a relatively modest policy. The high schools and the other institutions that are preparing people for college are becoming more unequal. They're not becoming more equal. And some of the states that have really most drastically cut back their educational systems are where the minority populations are most concentrated, like California and Texas. If affirmative action ends, we're going to be seeing things like this. By the way, if affirmative action ends, it will end here as well as in the public, because it will be a violation of the Constitution to practice affirmative action. This is exactly what the Reagan philosophy was. It's just as bad to consider race positively as negatively. You will lose your federal aid if you violate the Constitution. So, and if you lose your federal aid, the university will shut. So the private universities and publics will lose affirmative action. Minority students will be more isolated. There'll be major fights about how to rethink admissions processes. And the outcome of those fights is not clear. They'll probably differ widely between institutions. And there will be a decline in preparation in graduate and professional schools, schools like law and medicine especially, which are have very test-driven admissions, and have really been hurt very, very badly in the states that have lost affirmative action. What do we need to consider now? Critically looking at what's happened where we don't have affirmative action. Factually, seriously. It's been looked at a lot in California, but it hasn't been looked at a lot in Georgia, Florida, and some of the other places it needs to be looked at. What do we do in terms of civil rights policies outside of affirmative action about housing and school integration? What do we do about whites not being trained to be successful minorities, Southern California and other places, not understanding the context in which they'll be living and working? What do we do about leadership training if the institutions that produce leaders aren't diverse anymore in any significant way? The institutions, if all the leaders of the African American and Latino communities are going to come out of CSU instead of UC, what's that going to mean for those institutions? What's it going to mean for the people who are trained? So we may have affirmative action illegal 4 months from now. This has to be decided by the end of June when the Supreme Court's term ends. There's going to be a very serious need, if we lose affirmative action or if it is cut back seriously, to document what's happening, document what the choices are, what the effects of those choices are, and to get ready for the next Supreme Court decision. Because this will be a decision by one vote majority if it is decided that. And justices aren't immortal. Courts do change. And we have to think about it in the long term. If you think about what the civil rights groups thought were dealing with when they started working early in the 20th century to actually change the racial system of the South, they were working against a 9-0 Supreme Court. We've got a 5-4 situation now. One justice change could give us a chance to reopen this issue if it is closed for a while. So research in this area is going to be very, very important. And those of you who are trying to think about what your next project might be, what your dissertation might be, and so forth, think about this as one of the issues that you'd be concerned about. And even if you don't, just as a citizen, be involved in these discussions, because if we do have a major change, there will be a huge discussion here at your home institution and all the institutions you're concerned with, and it will be consequential. Thank you very much.
Thank you very much. And open up the room for any questions.
One thing that's bothered me, I'm a product of Mississippi, and I went to school here, the graduate program. I came here to go to UCLA and found out that UCLA was one of the most segregated, universities in the West. And so it wasn't because of that I wound up at USC back in the late 80s, in the late 70s, early 70s in the professional and graduate program. But one of the things, that argument about white kids, Baki and others have used, they discriminated against me because I'm white. When you have a 90% white student body, how on earth can they use that argument effectively when prima facie evidence says 90%, white students get 90% of the preference? How can you argue that you would deny admission because you were white?
Well, if you have 5 votes.
Oh, yeah. Well,
I'm a political scientist, so it comes down to the basics sometimes.
But can that argument be undermined? I mean,
well, basically, if you consider this at the individual level, you say, basically what the Supreme Court is moving towards is an idea that there are no big structural barriers left in American society. Therefore, we just look at each individual being treated fairly. And if an individual is discriminated against, they can sue. And if they can show that they weren't admitted because of their race, the court will order them. What they're upset about is all these systemic plans that do this on scale. And of course, it's very difficult to prove the reason why you lose out on something like this. It's almost impossible unless somebody confesses. You know, if you have to prove racially discriminatory intent, you almost always lose.
Well, why can't a black student or a Chicano student at the same time go into the case at the same time a white student does and say, I was denied admission because of my color?
They have a right to make that case.
Yeah.
If they can show if they can prove that, they'll be admitted.
Yeah.
But proving it is almost impossible because you're going to be dealing with a committee that had lots of different people and lots of different voices and various objective measures and so on and so forth. So what we say in civil rights is if you have the burden of proving racial intent, you lose, unless you get really stupid people that you're fighting against, who actually write down, we didn't admit this person because he's black. You know, you can't, it's very difficult to prove. So, you know, that's basically the reason why we moved towards race-conscious systemic remedies on all these different fields in the 1960s. The individual level issues were impossible. Yeah. Talking, both of you.
My name is Rossier, and I'm a postdoctor, but before I came to USC, I worked in the undergraduate admissions office at UCLA from 2001 to 2006. So I was part of an admissions office in the UC system that was implementing admissions policies, in particular comprehensive review, without the aid of affirmative action to get a diverse undergraduate student body every year. And I am the first person I've ever heard present on this topic that said exactly what we knew in the office, and I know that when you take away affirmative action, especially in the UC system, what you are not able to admit is that IQR of historically underrepresented students like myself, when I was admitted in 1996, that were, you know, are not at the top, they're not valedictorians, but they're pretty well prepared academically. They're going to be pretty successful.
That's right. You know that they succeed in your institution, but you can't admit them.
Yeah, so you can only admit with comprehensive review, you end up admitting very, very high qualified, academically qualified underrepresented students, and pretty poorly academically prepared students who have higher life challenges that factor into that comprehensive review. What do you believe as sort of what do you perceive as the reality of how admissions offices and schools administrations have not adequately sort of explained that reality to the public? Because I think I've always believed that if you do explain it like that, because that is what happens, that maybe you would win over some people on the other side who are adamantly against affirmative action. When you say you're now not admitting students who don't come because they have a bunch of different options, especially in private schools, and then you have students who are, you know, have less of a chance to succeed, especially when academic student support services.
What we're dealing with in the UC now is we have tons and tons of students who could profit from coming to the UC and would succeed in it that we can't admit. You know, because the capacity has been frozen for a generation while the number of students has exploded and the level of preparation of students has increased. So we have a tremendously difficult process, and it's, you know, everybody is feeling squeezed by it. I mean, I was talking to a college professor from Northern California who's white, and, you know, she said her son or daughter didn't even apply to UCLA because it's ridiculous. But what I think we have to do is, you know, we have to talk about what's happening in the bigger society, because what's happened in the Supreme Court is that they don't see there's any big racial problems left in the society. They think we used to have them, we solved them in the 1960s. You know, Martin Luther King made his speech, he got his monument, we passed the laws. now the danger that they see is that we're being unfair to white people and Asian people. You know, and that they don't see any systemic problem, therefore they don't think that any systemic plan is necessary. Certainly what you say is absolutely true. There's a lot of students who would make big contributions to our campus that don't get admitted and can't be admitted in any honest way in the absence of affirmative action. There isn't a good substitute. I mean, this is the basic reality. We've been thinking about this and looking for it for a long time. There's nothing that's as efficient and as effective as affirmative action. And affirmative action isn't that great either. You know, it's a limited tool, but it's better than any of the alternatives. Yeah.
We use the word diversity. I don't see anywhere where we have to get operational definition of it.
I can't hear you very well.
We have the word diversity, we throw it out.
Yeah.
I never see an operational definition of it. Other than.
Yeah, well, this is the other problem.
The other case too that
Yeah.
I'd like to see some commentary on is that I think on people of color who have been able to navigate, say, higher ed or high school, that there's really an embracing of one's marginality in order to be successful and to be able to put a call for it to get there. So if you just submit it on the basis of, I think we have to move somewhere in high school and showing students how in fact to embrace their marginality and learn how to cross borders, rather than, you know, otherwise break forever.
I mean, this whole area is just full of complexity and psychological and sociological dimensions of many sorts. I think that many students, as they come into college, do embrace their ethnic background and so forth, and they, in an affirmative action setting, it helps them get access, and maybe they should not have to do that. I think what we want to end up with is not where somebody is marginal and gets admitted to a predominantly white, or in our case, predominantly Asian institution, and is allowed to be there, but we want to change these institutions. And what's called marginality should become part of the centrality of the institution.
I would think the marginality would become centrality, and also embracing marginality by the majority, quote unquote.
But what we're finding in these surveys is that the students who are admitted under affirmative action feel better than the students at the places that don't have affirmative action, which is just directly contrary to a lot of the stigma arguments.
And I think, you know, when you get students of color that are in advanced placement classes or honors classes, it's actually begun the process of embracing marginality.
Well, hopefully we should actually get those classes really integrated.
Yeah.
You know, that's the step that has to be taken. There shouldn't be marginal in the high schools. There should be much more consulting of people into those.
I don't think of it as marginal. I think of it as embracing the marginality. Like, you know, Strunquist talks about the marginal man who's able to embrace the marginality, therefore see the world in reflexive terms rather than absolute terms.
I think in terms of the demographic transformation that we're in, we have to think who is marginal and who isn't, you know, because basically blacks are getting isolated in a Latino setting, whites are going to be isolated in a largely Latino setting. Asians are the only integrated population in California, and by far the most successful, you know, but they are getting class isolated. We have a lot of things to think about how this society is going to work out. And it's not going to, we don't have a model because we're at a stage of transformation that no place else in the country has seen, and very few places in the world have seen this kind of extremely rapid change in ethnicity and change in culture. You know, we have to make it work. We have to figure out how to make it work. It's not going to be a straight line process. Yeah.
So I always say that I'm a proud recipient of every affirmative action program there was at the very height of it. And I'm pretty sure that I would not have my own career had it not been for affirmative action. There's people from my generation. I mean, I was in college in '77.
You were in a great time.
I was in the greatest time of affirmative action. And that's what brings me here. right? And that's what puts me in the position I am in now. And I keep worry about current undergraduates that I work with, who I know are here because of similar programs, but have been taught to only talk about diversity and individual achievement. And therefore, they can't place themselves historically in the moment of time that they're in, possibly except if you know, affirmative action is removed and all of a sudden there isn't people like them coming behind them from their own high schools, from their own thing. Because I think that's, I talk to too many young people who don't understand their moment in time. Yeah. So I guess I'm wondering in this process of, you know, the next 4 months and the period afterward, if there's what you would suggest about teaching our undergraduates today about the moment of time that they're living in.
I think this is a really, really good question. I hope everybody heard it. How can we help undergraduates understand the moment of time and what the historic forces are that have produced this moment, and, you know, that they, you know, it wasn't always the way it is now, and it may not be in the future. That progress is not one directional in these big fights about the futures of societies. It goes forwards and it goes backwards. My wife and partner in the Civil Rights Project, Patricia Gondra, and I have been teaching a big undergraduate class called Equal Rights and Unequal Schools, the American Dilemma, trying to show the tension between rights and educational opportunity in several dimensions over time. And what we find is that the students have almost no historic perspective. And they're shocked and they're fascinated, really fascinated. And a lot of them change their plan about what they want to do with their lives and so forth. I think it's really been an extremely rewarding kind of teaching experience. People don't know how residential segregation got set up. They don't understand the de jure segregation model, or how recently. They don't understand intergenerational effects of inequality. They, you know, basically, there is a tremendous, in the electronic age, last night I was at a lecture by Howard Gardner, and we're talking about ways of thinking. But, you know, right now students are totally suffused with the immediate present. They just have infinite access to it everywhere in the universe, right on their computer screen. But they don't have a deep understanding of the past, or how we got here, or what it was like. And nobody teaches it to them. You know, it's a shame. And it's empowering if you know. I mean, one of the reasons that I was so fierce when I saw a lot of things happening in our society was that I did study the history with John Hope Franklin and others. I knew what had happened, and, you know, I could see it happening again. It's very empowering to have that kind of perspective. So I think, and it's very fun to teach it. So I would really recommend it. Yeah.
I'm wondering about Justice Kennedy, since you say...
I am too.
Yeah. And so my question's about that. In your experience, you know, when Sandra Day O'Connor was the swing vote,
yeah.
you know, and now Kennedy is, you kind of hope that that responsibility weighs heavily for them, and that they do things like read the amicus brief. And I'm wondering to what extent you think the arguments you put forward, given his past notions that diversity is important, not that he believed Michigan, but that can he get over that distrust and buy any of those? I mean, to what extent do you think those arguments might be, and maybe which ones might be influential?
You know, I have no idea. They live a very, very cloistered life. I used to live 2 blocks from the Supreme Court. I could see it from my study when I was working at Brookings. And I used to walk around it all the time, and there'd be a light on late at night, and I thought, which justice is it up there changing our society? But you don't know. I mean, and it doesn't leak out. Even people who know the clerks don't have any idea what's going on. So believe me, there's nothing that's more gossip-oriented than lawyers talking about judges. And I haven't heard anything about where Justice Kennedy's going. Yeah.
I grew up in Topeka. Went to one of the 4 pre-Brown black elementary schools in Topeka. My first cousin was the president of the Topeka NAACP at the time the Brown case was being
He
planned.
knew Oliver Brown.
And that's right, I knew Oliver Brown. And my cousin was Lucinda Todd, was active leader, and so much of the discussion about the Brown case took place in my parents' living room.
Wow.
In the early 50s. My question is there an
I've met
equivalent?
Linda Brown and her sister, and I've been out to visit the school at the
Yes.
historic site.
Monroe?
Yeah.
Monroe School, right.
Yes.
And, my question is there an equivalent groundswell of citizens who are involved in this current case, like it was in the Brown case? A great deal of the emphasis was the fact that community people were involved with the attorneys and helping to plan the case. I don't see the same kind of civilian participation.
No, it's really a distinct difference with Michigan. One of the problems with this Texas case is that the NAACP and the MALDEF, Mexican American Legal Defense Fund, weren't allowed to intervene. The students don't have any representatives in the case. It's the fight between the University of Texas and Miss Fisher. And Miss Fisher is backed by a lot of the most conservative forces in the country who were looking for a case to bring to the Supreme Court. So in Michigan, there was a group called BAM, by any means necessary. They're a mobilization organization. When the trial took place, when I testified, the court was full of black kids from Detroit. There were a lot of people involved and engaged. None of that has happened in this Texas case, because this is between the Texas lawyers for the University of Texas and the conservative lawyers for representing Ms. Fisher, who's by now graduated from LSU and has no interest in going to Texas. No, there isn't that kind of mobilization. I think there will be when affirmative action is abolished, if it actually happens, because there will be very bad changes in lots of institutions.
Thank you for your talk, Dr. Orfield. I'm a PhD student here. My name is Constance Elo. And I really appreciate you bringing up the detriment of this post-racial discourse, but one of the questions I had was, have there been any concerns in terms of affirmative action about its overemphasis on access to higher ed, but not, you know, emphasis enough on completion and, you know, universities benefiting from bringing in students of color, but not graduating them, taking their money, and then the environment overall just not being conducive to their success?
Yeah, a lot of discussion of that for many years. As a matter of fact, there's a lot more research on that than there was on the values of diversity for a long time. When we started trying to put together evidence that led to the Michigan case, we found all these studies by minority scholars saying how hard it was to be a minority at a white institution, which of course is true, but it wasn't helpful to us at all, because it would help the other side in most cases. You'd say, oh, if they're so unhappy there, why don't we just stop this process? But of course, everybody who has thought about this with the brain has thought about, you know, if we let the students in and they don't graduate, we're not doing anybody a favor. The fact is that the more elite the institution is that you're let into, the higher the probability of graduating. So if you are admitted to Harvard as an affirmative action student, you're almost positively certain to graduate. If you go to a community college, the chances that you're going to get a degree are, you know, 1 in 15. You know, so the colleges that are the most selective have the most infrastructure and the strongest orientation towards graduation. You know, so this is one of the basic findings of Bowen and Bach's work and many others. If you get into an elite institution that you might not qualify for without affirmative action, you will graduate. And the more elite it is, the more high the probability is that you'll graduate.
Mm-hmm. Yeah, I'm just thinking about some of the HBCU research that then says, well, we graduate students more, but then we also are more likely to send them to graduate school, whereas other elite institutions?
I think one of the most interesting things about HBCUs, especially places like Xavier, it has a wonderful science program, is that in elite institutions, lots of times the students of color who are admitted on affirmative action, who think they're going into science or medicine, change majors. There isn't enough support system inside those fields especially. And I think that's something that really needs to be addressed. Because at Xavier, they get much less qualified students in terms of preparation before college, but they just have a default that you are going to go to graduate school in science and so forth, which is very positive, very predictive of long-term success. And we don't have that in lots of our universities, especially in those fields. And that's a shame.
Expectations make all the difference.
Expectations and connections. I had a black student at the University of Chicago who was an undergrad who did a senior paper for me about how black students survive there. Only 3%. Chicago doesn't have any affirmative action to speak of, even though it's in the middle of the biggest black and Latino communities between the coasts. It's very selective and never really went into affirmative action. So this student said he thought these students were going to feel isolated and unhappy and socially frozen out and so forth. But he found only 2 variables that actually predicted whether they would succeed. One was, were they doing okay with their courses? And the other one was there one faculty member that cared about me? If those 2 things were there, then social stuff and so forth didn't matter very much, and they did graduate. And of course, if you're a black or Latino student who graduates from the University of Chicago, you can go to any graduate student school in the world. Everybody knows what it's like. It's rigorous. Yeah.
What about using the community colleges more strategically? For example, Southwest is majority African American, and what we've seen now is that the regions increase the quota of non-resident students, and the regulation that's supposed to help students transfer are making it more difficult for students to actually transfer. So if the UC system could use more strategically, they could get more African American and Latino.
Yeah, well, many of our students of color do come from community colleges. And there's a very strong transfer path from Santa Monica, for example, which really has good support for students of color. We just did a study that looked at 112 community colleges in California, using longitudinal data. We found there were only 5 that, in the period that we examined, that successfully graduated and transferred any significant number of students from weak high schools. And those were rare. There were none that did it for both black and Latino students. There were 2 for black students and 3 for Latino students. It's a very, very weak system for most students. And it's not that there's not a lot of transfers. A lot of the students that end up in UC are transfers. It's that most of the community colleges that most of the students from weak high schools go to are weak themselves and don't really prepare anybody for transferring to really competitive campuses. And we have to think about that because it's deceptive. We should let students know which community colleges you should go to if you want to have a chance of transferring successfully. Well, the other thing you said is important too. Under the financial pressure that we're under in California now, the public universities are trying to recruit higher paying students. So we're taking a lot more international students now at UCLA. We're not cutting down the number of California students that are getting in, but we're raising the number of non-California students. And the more successful CSUs are trying to do the same thing, and some community colleges are trying to do it. Because some community colleges are backdoors for Asian students from Hong Kong and so forth to get into the UC. We have to think about these things. If you squeeze the system too much, a lot of irrational things happen. And we have to think about it.
I wonder, since the court took a case that is moot, and it seems like it's taking almost a political stance for education here.
Yeah.
Do you think that in ed law, the next phase will be to cut down the infrastructures that we have for students of color once they're actually in the dorms?
Well, 2 questions. One of them is this case moot, and was it a political action to take it? This is exactly what the University of Texas argued. This isn't even a case. For those of you who aren't familiar with the federal courts, the federal courts are not supposed to, our federal courts are not supposed to decide theoretical issues. It has to be a real case for them to take it. And this is not really a real case when you think about it. And when you say it's, what moot means, it means that the issue is irrelevant, it's no longer in need of decision. They thought this was moot, and they thought that it was inappropriate. And many people do see this case, taking this case as a political act, because it's the case that's most favorable for knocking down affirmative action because you have the percent plan. So, you know, all these 5 board votes aren't just about theory. They are about values. And if you call that political or ideological or whatever, it matters. And this is a very inappropriate case. But so was, you know, the decision that they made to allow unlimited expenditure by private corporations in American elections. The parties weren't even asking for that. They were asking for much less. So this is a court that's pretty political, and it has been. You saw that in the election of President Bush following the Supreme Court decision on a 5-4 vote. This is maybe one of those politically and ideologically polarized courts we've ever had, and you know, but it's extremely powerful, and it does have the power to change all of this in one day. Thank you very much.
Thank you. And a small gift for you. Thank you very much. And thank you all for coming. Really appreciate it. Thank you so much.